Mr. Banner.
My lords, my lady, I'm going to start with a couple of tidying up points, and then I'm going to deal with Sage, and if I have time, Lucas as well, in that order, remaining 15 minutes. First tidying up point, the 673 versus the 67 Commission. We've looked into that over the lunchtime adjournment. The answer is actually the references in the 97 post-87 consents are to the 67 permissions, because all the permissions from the early 70s are the same reference number. If you look through, it's actually easiest to look on the permissions bundle, but they 231MS, the original one, is TOW U 1015P. So too is the next one. So too is the next one. And then in page 4873, it becomes TYW. I'm instructed that the reason, I think Mr. Lewis and I, we hope to be able to agree a note, if that would help the court on this, that town changed from the English to the Welsh language in the intervening years, so hence O became W. Mr. Lewis is the expert on Welsh language, not me. But that is, so actually they're all, so I was confused, I'm afraid to say, and apologise to the court by the reference to W, thought that must be 673 rather than the earlier ones. Of course, not anything below turned on that, but it's not, it's a reference to the original. And also, it's not before the court, though there is reference in materials, including my learned friends, to the layout, quote unquote, being changed by 73, they were also localised. It wasn't a substituted new overall layout plan. They were focused, localised change of the same nature of the others. So there was nothing qualitatively different about the 73 Commission to the others. So sorry if I've sent you barking up the wrong tree on that. And that's reiterated by Mr. Justice Drake, finding and indeed declaring that the 1967 Commission had been begun as a whole. Secondly, before I turn to Sage, I forgot to deal briefly with the examples. This is under the heading of the sixth submission, which begins at paragraph 62 of the printed case, MS 75. We gave some illustrative, non-exhaustive examples just to give a sense of the range of situations in which the Court of Appeal and High Court's judgments have caused or may cause problems. Mr. Lewis has his response. I don't have the time to deal with them in great detail, and they are only illustrative, but can I give you my headline responses to his points? So his case at paragraph 98 and 99, which is MS 119, for the first example, his response is predicated on his submission that the local authority isn't able to consider the interrelationships when considering a quote-unquote variation application. I say it is and must. So essentially he relies upon his false premises to rebut that example. The second example, which relates to a proposed building which would be for office use, and before it's constructed, a building with a wider development, that building, they want to change it to a different kind of use. And Mr. Lewis says, well, that would need a change of use application, and that wouldn't engage the Pilkington principle. But what that overlooks is the building isn't constructed, so it actually have to be a new planning permission for the construction of the building as whatever the new use is, a hotel, as opposed to a change of use because there's no building to change the use of. So his response to that, I suggest, is not valid. And the third example, which is over the page at 101, I apologise for having to deal with this as a canter, inevitably. The third example concerns an outline commission which has three phases. The first two phases have reserved matters approval, but the third phase is just out time for reserved matters approval. And there's a drop-in for something different in that third phase. And he says, well, because it's an outline permission where there's no reserved matters approval for the third phase, there's no Pilkington inconsistency or incompatibility, whatever phrase you want to use, between that permission and the other. But I suggest that actually rather undermines his submission based on Sage, because his whole point, his whole case based upon Sage is you have to complete the whole lot, and if there's any departure of what was contemplated by the permission, then the overall whole can't be built, and subject potentially to the sufficient compliance doctrine, if you can't complete the whole lot because of a later permission, that's it. So there is still an inconsistency. So I'll wait to hear what if anything he makes of those. And ultimately, it's only so far the court will be assisted about a debate about hypothetical examples. But I do say, for what it's worth, that he hasn't demonstrated that examples don't assist in showing the breadth of the issue. I'm going to turn now to SAGE, and the submissions on SAGE are at the fourth submission in the printed case. My learned friend...
Page?
Sorry, that's page MS 69 to 70.
Thank you.
Now, my learned friend says in response to these submissions that really SAGE didn't come into... wasn't really material part of the Court of Appeal's reasoning on the issue that's before this court. He says it was only in the context of the raised judicata issue that Lord Justice Singh dealt with it, and that's the point made by my learned friend at paragraph 77 of his case, page 112. I'd say that's not right for 3 points. I'll just deal with those briefly so that you understand why what I then say about SAGE is relevant. Firstly, at paragraph 65, Lord Justice Singh considered that the SAGE was relevant in the res judicata context because it was a legal development of significance. Well, plainly, what he meant there is of significance to the substantive issues, as opposed to of general academic background significance. It's also, second point, my learned friends...
What's said in paragraph 65, second last sentence?
I'm so sorry, my lord, I didn't hear that.
But the second last sentence of paragraph 65 is simply wrong, is it?
Yes. I'm just getting it.
It's now become clearer than it was before 2003 as a result of SAGE, that a planning permission needs to be implemented.
Well, it didn't mean SAGE was... Yes. Quite. There's all sorts of responses to what I said. I'm going to come on to SAGE, but you're quite. And secondly, SAGE was relied upon by the Court of Appeal at paragraph 86, expressly in relation to the substantive issues, because 86, there's reference to the general requirement development must be carried out fully in accordance with the permission granted for it, which is how Mr. Justice Hickenbottom, as he then was, took SAGE to mean in the Pilkington context in the Singh case. And finally, it overlooks the context because the prefacing paragraph of the reasoning of Lord Justice Singh, at paragraph 44, says that counsel argued, wasn't me at the time, but counsel argued the raised judicata and substantive points collectively, and he dealt with them collectively because of the synergies between them. And ultimately, when one reads the judgment of His Honour Judge Keyser below, and indeed my learned friend's opinion, which started the whole process, SAGE is a cornerstone of the analysis. So the written submissions on SAGE, which I won't repeat or duplicate, are on page 51, paragraphs 51 to 53. The critical steps in the analysis, I suggest, is firstly, SAGE, which I'm going to take you to brief in a moment, concern the statutory time limit for enforcement in the context of a single building built without planning permission. The time limit was expressed to run from when the development had been substantially completed. That was the term used in the relevant section of legislation. And so the central issue was whether the whole building had to be substantially completed for the time limit to run, or only those operations requiring planning permission, because ordinarily internal operations alone that don't affect the external appearance don't require planning permission. They're excluded from development. And so Mr. Sage's point was I didn't need permission for those, and those provided I created the shell of the house, that was enough to substantially complete the building. And the House of Lords said that was wrong. So that was the issue in the answer stage. Pilkington and Pioneer, they weren't even cited. I mean, it simply wasn't a case about this issue. And if I can ask you to go to MS 799 to make what I've just said good. Draw attention in the head notes between D and E. The building was partly erected no building code out during the 4 years preceding service and enforcement notice, 4 years being the time limit, the time limit started. The building was unfit for habitation, the ground floor was rubble, no service fitting, staircase, etc. But Mr. Sage said, well, all of those wouldn't be development in the first place. That was his case. Over the page 800, you see the cases cited to their lordships, not including the Pilkington line. Then page 802, paragraph 10 of the judgment, you see the relevant statutory provision. And then I'm going to have to just give you the reference, but on page 805, page 989 of the law report, there you see the core of the argument I've just summarised about the internal operations not counting. And then that is the context for on page 806, paragraph 23, which is subsequently read across. And I say that one has to read paragraph 23 in that context. What Lord Hobhouse had in mind, I say, the court can take in his observations on the holistic approach of this part of planning law was the holistic approach to the single building that was before him. That was the critical issue before the court. See also Lord Hope at paragraph 7, who expressed to be in agreement with Lord Hobhouse. And it's clear there, the last sentence, B to C, the building as it stands. That's what the court were looking at in that case. Finally, can I go then to, in this heading, to Robert Hitchens? That's at page 779. Not sure how distant a memory it will be for my Lord Sales.
Yeah, very,
Probably
so
very
distant
distant,
as to have receded over the horizon.
Exactly, but you were there. And the facts basically were two permissions in identical terms for development. The first one, granted by the local authority, had an obligation to make a transport contribution of a large amount. The second one, granted on appeal, because the authority insisted on that obligation, didn't have that. The developer had started the works under one and wanted to switch to the unconstrained permission. There was a Pilkington point which the resolution of which isn't of sufficient significance for me to spend any time on. But Sage was also relied upon to say, well, if you switched halfway through, you were falling foul of Sage because neither permission would have been completed as a whole. And Sage is dealt with at page 795 through to 797. I endorse what Lord Justice Richards, with my Lord Sales and Lord Justice Floyd also agreeing. I endorse entirely what's said there. If I can draw attention in particular to, on page 796, the section, his point was about 8 lines down. The point was that if a building operation doesn't call the planning permission, that operation, so for example, a building is built in a way that departs from the permission, the whole building, not the departure, is unlawful. He wasn't saying if a building is built in a way with planning permission but isn't completed, the whole building is unlawful, let alone was he addressing the situation where a building is completed pursuant to 2 identical permissions, one after the other, and he goes on further problems with the counter-argument. The second of which would be if planning permission was granted for 200 houses, of which 150 were progressively built out and occupied, that would be unlawful unless until the remaining 50 dwellings were built, even if the 150 were all individually according to their plans and no breach of any condition of the permission. But that, I say, is right. It's supportive of my reliance on Lucas, which is essentially a fallback, as I've made clear in this written case, and also it's supportive generally of my approach to this issue.
Presumably, planning control is directed to you having permission at the time that the development takes place. So if you're building out a permission, you do have permission at the time that it's being built out. And I think you're saying that there isn't anything in the planning legislative regime which imposes a condition subsequent that says, well, if you don't finish the whole development, everything that's happened before.
Well, that's right. I may not get onto Lucas, I have to take it, but in Lucas, the courts, I've highlighted in the printed case, the court said it would be open to authority if it felt it particularly important to impose a condition requiring that or something to that effect. And I think it's at page 1. Let me give you a reference because I don't think I'm going to get onto the detail of it. It's
put in a nutshell by Lord Scarman and in Pioneer Aggregate
Yes.
at 740, letter between C and D, where he says planning permission reveals its true nature, a permission that certain rights of ownership may be exercised, but not a requirement that they must
They must be, indeed. And it's 704 in Lucas talks about, well, the permission could have a condition, and there's certain formulations of that suggested in Lucas.
Even then, the way you condition it, at least as I recollect it, is not to say you must complete, but to say you may not, for example, houses may not be occupied until
yes.
the roads have been adopted.
Trigger points, yes. And there's a real there are the aspects of my learned friend's case, and of course left open at paragraph 68 of Lord Justice Singh's judgment, aspects of the case against me that certainly give the impression if Mrs. Jones was to buy a house in phase 1 of a 4-phase development, that her ability to get a remortgage or to sell her house, for example, would be in jeopardy if the developer went bust before phase 5 was completed. I suggest that cannot be right, and the court should strive to do everything it can to make that clear for all sorts of fairly obvious reasons. Note also the JPL editor that I mentioned before on the Pilkington point at 797. The much misused and entirely obiter comment. I'm not sure I completely endorse the reference to entirely obiter, actually, but be that as it may, it doesn't really matter at this point. But I say they're misconstrued. I think properly construed, they weren't obiter because they were related to the building point in that case. If they were broader, they clearly were obiter.
Where are you reading from? I'm sorry.
797, the bottom paragraph.
Of the comment, this is.
Yeah, the Court of Appeal took the opportunity of considering the much misused and entirely obiter comments of Lord Hobhouse in Sage, i.e. paragraph 23. Now, I don't really endorse the obiter because it seems to me if paragraph 23 is construed in the way I submit that it should be, the narrow way, then there it was on point and not obiter. If, however, it is construed broadly, then it is obiter, and in any event, whichever of the two, it has been much misused, and with great respect, it's been misused so far in this case by the courts below, and with great respect by the authority. I'm at the end of my time. I'm going to take, unless you've got any questions, my lady and my lords, on Lucas, I take that. Just to make clear on Lucas, it's the reason I say it's a fallback is because if the Lucas approach to interpretation is applied to this permission, then even if I'm wrong on everything I've said so far in terms of the Pilkington principle and its application in this context, the elements of the 1967 permission which can no longer be built out because of the later permissions are severable, and so therefore there's no inconsistency. So that's why I characterise Lucas as a fall. It's not a necessary part of my argument, but actually gets me home if everything I've said until now is not accepted by my lady and my lord. Unless I assist the court further, that's all I wish to... Oh, and sorry, very lastly, the plot numbers, the only document that's got it so far before the court is 299. If you'd like anything further, we can agree to probably an agreed note or something like that.
Thank you very much.
Thank you.
Can I just take you back to what's bothering me at page 438?
Okay, 1 second, let me look at that.
Which is the plan of the current building superimposed on the 1967 plan. Now, when you built
Yes, I have it.
when you built what's there at G with those three houses, clearly some of the road just north of those goes over what was supposed to be houses, and you can't build those now. That's physically impossible.
Yes.
But what is it that stops you building those three houses just where the letter G is? Or do you say, yes, we could build those, we could build those two little houses just abutting the road, just north of the road there?
It's easier to answer that question, if I may, my lady. If you're able to, keep 438 open, go to 299, because there's two competing plans. If you have, because the plan that has been produced, which Mr. Maiden, who wasn't actually cross-examined, explained why it's more accurate in his witness statement before the High Court. this shows on a more granular basis the consents and by reference to the various additional permissions. So I think my lady's talking about where it's 1 to 6 effectively, and then it's really the back gardens of 1 to 6. And as you'll see, actually, that they what would be to stop them is that they've
that
been
would
built.
be a real Pilkington situation.
Yeah. So it essentially, essentially, I think what you're asking me in substance is, what do I mean on the facts by the areas affected by divisional consents? And that my answer to this is twofold. Obviously, anything actually physically within the area, because that can't be, that's been superimposed now onto the 1967 master plan. If anything, either in this situation or in another situation, plainly if the red line of an additional permission straddled half a house, then plainly that would mean that the other half of the house, authorised by the earlier consent, couldn't be built. So any specific...
The whole of those houses could be built, but you're saying because they're shown as gardens...
I'm not sure I completely accept that.
Well,
actually.
assume for the moment that but if they were built, it would be a completely different sort of density of...
My submission, based on the 299 plan, and again, if I may, I might come back on that just in case I've misstated, but my submission would be actually that the houses where the letter G is couldn't be built, because they are now within the area on the better plan, they're within the area superimposed. But the answer in any case, which I say is a fairly easy one to work out, is what under the original consent physically can't be built. And my learned friend said the question is the whole development. I said, for the reasons I've given, that's not right. But you look and say, for anything that's superimposed... Yeah,
but supposing that had superimposed houses over what's the main access at the top of that, right?
Yes, they don't, but yes.
So then that would mean that for all these houses right out to the east, there would need to be some different access.
Which would have been a very material consideration at the time to work through.
Right.
But it should have been worked through and not now open to go back through a process.
But then do you say that means that you're entitled to build all the rest of the plan without providing access to these houses?
Yes, because that's whether we would in fact do that seeking, because what one has to understand is the chronology of additional permissions hadn't necessarily ended at the time of the last one. The process was halted because of the local authority's U-turn. If this court were, for example, to hold that actually the local authority got it right the first time and was wrong to do the U-turn, then there might not be, but there could be, in principle, other appropriate applications to modify, which may be done not just to make things work in planning room, but for commercial reasons. I mean, ultimately, my client wants to make some money out of this, and therefore providing the best possible development, bearing in mind what's said in the evidence about the desire to make this a high-quality development respectful of its setting. He doesn't want to make it, a bad place. So all of this can be worked out, and the council below was right to say it can be worked out. And it does actually work on the plan. So if one looks at 299, it does marry up. Any suggestion otherwise is simply wrong. But I say this is not a planning inquiry into the variation permissions. And my learned friend, I'm sure, in any moment now will seek to convert it into one. But it's not, and that's in breach of the principle of regularity and formal validity, as I said. I hope that answers your question, my lady. If it doesn't, I'll try and answer it again later in reply. Can I assist any further?
Thank you very much.
Thank you, my lord.
Mr. Lewis.
My lords, my lady, my submissions for the authority will be in 4 parts. First, I'll give an overview of the authority's case. Secondly, I'll deal briefly with the facts, conscious that we're mainly concerned with the point of principle. Third, I'll deal with the law relating to multiple planning permissions. And fourth, I'll provide the authority's response to the 8 main submissions that comprise the appellant's case. I provide first an overview of the authority's case. In the High Court below, we say that the judge was not only right to conclude that it was no longer physically possible to carry out the development authorised by the 1967 permission. That was, we say, the only conclusion reasonably open to him on the facts, given the extent of conflict between the development carried out on the site since 1987 and the 1967 master plan. Now, the appellant seeks to avoid that inevitable conclusion by contending that the long-established Pilkington principle of physical impossibility, and that, I stress at the outset, is what we're concerned with. It's a principle of physical impossibility, not physical inconsistency. My learned friend contends, well, that long-established principle should be modified so that it doesn't apply, he says, where parts of a larger development are, to use the appellant's language, unaffected by development carried out under subsequent permissions. That submission, we say, is wrong in principle, because the question of whether it would still be acceptable in planning terms to build parts of a larger development claimed to be unaffected by development carried out under conflicting permissions, that is not a matter to be determined privately by the developer. That is a matter of planning judgment to be determined by the local planning authority in the public interest in response to a fresh planning application for the development now sought to be carried out. And I note that we have what appears to be at least a half concession towards the end of my learned friend's submissions that such a fresh planning application might indeed be necessary in any event. But what Parliament certainly did not intend, my lords, my lady, in the Town and Country Planning Act of 1990 was that a developer should be able to, as I term it, pick and mix, take a pick and mix approach to different parts of different planning permissions for the same land without having to obtain the approval of the local planning authority for the final preferred mix. That, we say, would be the antithesis of the planning control sought to be achieved by the Act in the public interest. And the Pilkington principle in our submission should be left as it is. I move to the second part of my submissions, the facts. There are two basic matters, my lords, my lady, that are not in dispute. The first is that against the background of the 1967 permission, having granted permission for 401 houses on the land, it's agreed between the parties that only some 41 units have been built on site to date, with a further 6 under construction. And that's shown, as we've seen, on the annotated master plan at page 438 of the electronic bundle. And we can see the houses built there or under construction. They are outlined on page 438 in dark grey. The second matter that is not in dispute, and we can also take this from the annotated master plan, is that none, precisely none, of the 41 units has been built in accordance with the master plan incorporated within the 1967 permission. And we can see that on the plan. The red outlines show the houses as approved on the original 1967 master plan, and superimposed on that are the dark grey outlines which show what's actually been or in the course of being built.
And I think I understood you to say this morning that's also true of the 6 which are under construction.
Indeed so, my lord, yes, indeed so. And the court will see there are significant differences when one compares the grey and the red, some more significant than others, granted. But there are differences relating to layout, orientation, houses of a different type and size than those permitted in 1967. And those differences in the developments carried out, they've been possible, as we've seen, because of a series of subsequent planning permissions granted in the decades since that 1967 permission was granted. Now, we're in the fortunate position in this court that the courts below have already set out the lengthy planning history and they've set it out accurately. I respectfully adopt the account of the planning history in paragraphs 3 to 16 of the judgment of the Court of Appeal below. And those, for the Court's note, those paragraphs start at page 137 of the bundle. And the trial judge, the High Court judge, he gave an even fuller, accurate account at paragraphs 6 to 22 of his judgment. That's page 157 of the bundle. Now, thankfully, there's a limit to how far we need to engage with the minutiae of the lengthy planning history, given the appellant's fair concession that there have been multiple significant departures from the 1967 master plan in the developments carried out since then. However, I would like to take a moment, if I may, to look in more detail at the original 1967 permission and the correspondence that preceded it, so that we understand fully the context in which that permission was granted. And I want to look through those documents, having in mind the appellant's submission to this court and to the courts below that the 1967 permission somehow comprised, and I quote my learned friend, individual permissions for each of the 401 dwellings.
That's his fallback case, but his primary case, as I understand it, is that as a matter of construction, each of the subsequent planning permissions was a permission to carry forward the 1967 development as modified by that permission and all the ones up to that point.
Indeed.
And so, I mean, as a matter of construction, if that's right, he doesn't have to rely on some principle of severing the planning permission into different parts.
He doesn't have to rely on it, but he's wrong on the point of construction.
Well, that seems at the moment to be the key crux of the case.
It will indeed be the crux of the case, my lord, and he is wrong on the point of construction for reasons that I'll come on to explain. None of the additional permissions, as I understand him, appears to accept, none of the additional permissions amounted to re-granting the original 1967 permission in modified form. He accepts that they were only permissions for smaller amounts of development in particular parts of the site.
Well, then you need to explain what the point was of saying it's a variation of the previous plan. If in fact it isn't reiterating the previous plan as modified.
And just in terms of the case that you're meeting, I did in fact understand the case to be, per paragraph 48 of the judge's judgment, that it was a regrant of a permission now in the modified form that my lord has explained.
My lord, that is not the construction that we say is correct of those permissions. I note what was said about the freestanding nature, or that they're not freestanding permissions, but that they're permissions to be interpreted in context. But let me deal with that point squarely now. When one looks at those permissions, one must focus as a matter of objective construction on the description of the development approved. And as we'll see in due course, none of those descriptions amounted to or contained words to the effect development of 401 houses subject to this modification. The description of the development on each occasion was in terms only of the smaller description approved by that permission. Yes, there was a reference towards the end, not in all of them, as we've seen. Indeed, post-1987, this was only true of a minority of the permissions, 3 of the 8 post-1987. Yes, there was a reference to, or couched in terms of, a variation of the earlier permission. But that was simply descriptive in my submission. As the Court of Appeal put it below, it was an indication that the authority was authorising a departure, factually, from the master plan. But what it certainly wasn't doing was re-granting the entire 1967 permission, and thereby, by doing that, confirming that the relationship between, or relationships between, those smaller developments and the wider whole would be acceptable. And there's a wider statutory context also to this.
But it didn't have to do that in order to constitute a variation. I don't think Mr. Banner. Well, I don't think Mr. Banner has to argue that there was a re-grant of permission for the entire site, which would effectively restart the time limit running for the commencement of development under the permission. But on its face, each of the permissions is a variation of the 1960 or 1967 or 73 permission. Is there any reason why they couldn't grant a permission which was modifying the earlier permission?
There would have been nothing to stop such a permission being granted, my lord, had that been applied for. So had there been, let us say, post its introduction, a Section 73 application saying, look, we've had a change of heart here, we want to change the arrangement, here's a different plan, and we want this plan approved pursuant to a different condition. That would have been an entirely different state of affairs.
So there has to be, the only way of the only legally competent way of modifying the permission is to have a fresh grant of permission for the entire development.
Well, subject to, my lord, because let me be clear, I'm not presenting a completely absolutist position to the court, because as I made clear in my submission, and indeed as the trial judge made clear in his judgment, there is room for some degree of pragmatism, and this is what one might call the orthodox or the typical application for a drop-in permission. Let's say someone has a scheme, a detailed scheme approved for some 100 houses, and once the implementation of that scheme has commenced, a decision is made to change the orientation, let's say, of the garage at number 97. Now, am I saying that in order to effect that sort of change and to obtain authority for that sort of change, that it's necessary to obtain planning permission for the entire scheme again? Well, clearly no. There must be some room for pragmatism, what's known in the trade as a drop-in permission, whereby one could tweak and one could end up with a situation where there's a clear, happy relationship between the root consent and the drop-in permission, because the degree of change is inconsequential. That is not this case. And this is why I take issue, with the greatest of respect to my learned friend, I take issue with the way this case has rather been missold by some to the planning press as being a case that is somehow determinative of the future use of drop-in permissions. It is no such thing.
Is it only where the degree of change is inconsequential that what you call a drop-in permission is possible?
I'm not presenting an absolutist position to the court where I say, well, on a strict approach, that really shouldn't be allowed either, because it's entirely conceivable as a...
Isn't that allowed by a Section 73 application?
Indeed.
Yes, so a drop-in, I didn't understand drop-in permissions being the same thing as Section 73 applications, or maybe I've misunderstood.
Well, if I can assist on that, my lady, and let me assist squarely with the questions that I'm asked at the time that they're asked, because I'm anxious to ensure that I'm assisting the court. Let's deal squarely with that, because there's in the articles that have been provided by the appellant in evidence, there is one article that perfectly encapsulates what we mean by a drop-in permission, and it's page 553 of the bundle. This is an article for the Estates Gazette by a, if I might say, highly respected planning solicitor, Mr. Simon Ricketts, a partner at Town Legal. If we look at the penultimate page of page 553, here we have an example or a description of what we mean in practice by a drop-in permission. It's some 5 lines in, and what's interesting is that the drop-in permission as a creature of practice, it is described in this article as something that is based on the Pilkington principle. It's an offspring of Pilkington. 5 lines in, halfway across the page, this principle, Pilkington principle, is the basis for the common practice of there being an outline planning permission for a large multi-phase development, and then in order to accommodate inevitable changes over time which cannot be delivered by way of Section 73, a drop-in permission for a different form of development proposed for a particular phase, usually accompanied by a Section 73 permission to amend conditions on the main permission so as not to be inconsistent with enabling that particular phase to be built out pursuant to the drop-in permission. Now, there's quite a bit of jargon there, perhaps, but...
Are you saying that drop-in permissions are confined to outline plans, to situations where the original planning permission was in outline only?
Well, that is certainly... I'm not sure I'd go so far as to make the absolutist submission that they're confined, but certainly as a matter of general practice, my lord, that is what we mean in modern practice when we refer to a drop-in permission. We are referring essentially to carving out a part of the wider site and then applying for a reissued, regularising Section 73 permission, carving out that bit that's got its own drop-in permission that then enables the two of them to sit side by side happily.
What sort of what's being envisaged? I mean, if you have an outline plan permission, you always have to put in detailed an application for detailed permission subsequently. So what's special about the circumstances where you would need to have a what's called a drop-in permission?
So, if I might give an example, my lord, sometimes planning permissions will be expressed in terms of planning permission for up to, let's say, 400 houses. Mm-hmm. Now, when the description of development is as flexible as that in the route permission, that creates scope for what is actually built out pursuant to the route permission to be less than that. Now, when developers are well advised and they try to obtain that flexibility in the description of development in the route permission, it enables them later on to have some flexibility. If, as was contemplated by my learned friend in one of his scenarios, there develops a problem later on in the implementation of the planning permission, which means that something else needs to be applied for. But context, my lords, my lady, here is absolutely key, because we see here the reference to an outline permission and a Section 73 regularising permission alongside the drop-in permission. Here, of course, in our case, although the developer had open to him the right to apply for an outline permission and thereby obtain that additional flexibility that comes with that process, that is not what the developer elected to do in this case. And if I can go back, my lords...
There's nothing uncommon about applying for a final permission, even at the outset. I mean, it depends on the sort of development we're doing, but for some types of development, the planning authority and indeed objectors and so forth will want to know what in more or less precise terms is envisaged.
Indeed. And that's why I say also, my lord, the problem that we've had or that we've seen in this case tends not to arise as a matter of modern practice, because of course developers have rightly caught on to the advantages of applying for an outline planning permission. So to go back to my lord's observations this morning, well, don't we need some flexibility? Because surely when it comes to a matter of once you've got the consent, don't you need some flexibility if you're going to come across potential issues with ground conditions and so forth? Well, that doesn't happen when one obtains a planning permission in principle, essentially an outline consent, because of course there are then detailed applications made for the approval of matters, which requires all of those detailed matters to be resolved at the time the final consent or consents are granted as part of that package.
Yes, but there could be all kinds of reasons why you can't do that in practical terms. For example, one that comes to mind immediately is the proposed development in Paternoster Square about, whatever it was, 20, 30 years ago, where the application was to build a Mies van der Rohe tower. Now, the whole point of the application was it would be the only Mies van der Rohe building in the UK. And any other building was very unlikely to get permission to such a sensitive location. But the argument was that this would be such an exceptional, high-quality architectural achievement that that made the difference. So the only hope of getting planning permission was to put in an application for a detailed application.
But there comes a price. There might be all sorts of motivating factors, my lord, as to why one might decide to apply for a detailed planning permission as opposed to an outline. But the price that one pays by applying for a detailed, and as happened in this case, there was indeed an undertaking given in the application form, as we'll see in due course, that the master plan was going to be implemented and carried out in full. The price that one pays for seeking and then obtaining a detailed permission straight away is that one does then necessarily create a risk of not being able to deal as flexibly as one would with an outline planning permission if then there are certain detailed issues that come up.
But are you saying it was impossible to deal with those detailed issues in this case without putting in a whole new application for the site as a whole, or are you just saying they did it the wrong way, and if they'd gone about it properly, they could have avoided the problem that's arisen? Which is your case?
Well, my lord, I think, if I'm not mistaken, I think I'm saying both. I'm certainly criticising them for the approach that they have taken because, to put it bluntly, it was not the function of the local planning authority to keep this 1967 permission alive. The developer acted throughout with professional advice. It can't be incumbent on the local planning authority to have that burden upon it, to have that duty of trying to keep all balls in the air when there are multiple planning applications and permissions sought in relation to a particular site. But what I do say also, so I criticise them, yes, for the approach that they took, but I also say that if they do now want, and this does seem to be now conceded by my learned friend, if they do now want to continue with their aspirations for the wider site, the course that they've taken, that they've elected to take through their own planning applications and permissions sought, the course that they've taken means that they will need to try to regularise the connections with what's left. Because, let me be completely clear, and I'll come on to the detailed evidence in due course, what the state of affairs on the site presently would result in an entirely unacceptable outcome, both in terms of aesthetic planning terms, but also critically as a matter of highway safety. If the developer were to obtain from this court, and this is what they're asking for, it's rather curious, they're asking for a declaration from this court, essentially, that they can go away and just, without having to make any further application, that they can just go away and carry out whatever they want to carry out of the development in these so-called unaffected areas. Now that creates a significant problem from a public interest perspective, because no local planning authority, all of the ones that have acted in this case over the years, no local planning authority has ever had regard or had to assess at the point of granting those permissions whether the relationship between those smaller permissions and the wider master plan would be acceptable. Now, my learned friend says on that point, well, that was, in public law terms, something that you had to do. That was surely a mandatory consideration for you. That is incorrect. Let's test what my learned friend is saying on that. He's saying, essentially, that if he's saying that it was, in public law terms, a mandatory requirement to consider the relationship between the smaller development applied for and the wider master plan, that would be to require the authority to assess the acceptability of the relationship with development that's not yet been built. Now, that would be quite revolutionary as a matter of planning practice. First practical point, if I may, there's a more fundamental point, but the first practical point, what if there are 2, 3, 4, possibly more extant unbuilt permissions for the larger site?
Yes, but you know which one it is because your own permission identifies what you're doing as varying a particular earlier permission.
But that goes to the fundamental point, my lord. Let's just focus on that. Are we saying that there was a legal requirement in public law terms to assess that relationship?
That's effectively what Lord Widgery is saying in Pilkington.
Well, I don't accept, my lord, to use Lord Widgery's language, I don't accept that this was a special case of incorporation. For there to have been an incorporation of the 1967 permission, there would have needed to be, as I put it, a re-grant of the 1967 permission in modified form.
What it says is 724 FTE, special cases will arise. He's saying the general rule is you treat each application on its own merits. But he's saying, of course, special cases will arise where one application deliberately and expressly refers to or incorporates another. In the absence of any such complication, I regard it as a duty of the planning authority to regard each application as a proposal in itself. So by implication, if you have an application which does refer to or incorporate another, then you don't treat it as an application in itself. You have to look at it in the context of the other one to which it refers or which it incorporates.
Indeed, my lord, but each case turns on its own facts, I say, and I go back to the description of the developments in those additional permissions. What we don't have in any of those additional permissions, and let's, if I may remind ourselves that we're concerned here with the likely scenario is that this needs to work from a planning registry, a public registry perspective. There will be a planning register of planning permissions that members of the public will consult when they're making house purchases and so forth in order to understand what's happening on this piece of land. A description of development that makes no mention at all of granting planning permission for 401 houses, but simply refers to a smaller development on a smaller part of the wider site, and merely includes essentially as a tail end a reference to a variation of an earlier permission. That is essentially, I submit, no more than a descriptor.
Well, you say it's a tail end, but if you receive from the local authority something which says on its face that this is a variation of the permission, you might be forgiven for thinking that it means that you can still build in accordance with the original permission, except as now altered by this application. You certainly wouldn't take it to mean that it means that if I go and put this up, I can't build at all under the old permission. That isn't a variation, that's a demolition of it.
But, my lord, that goes to whether the local authority, when it's considering such an application, is under an obligation to alert the applicant when he might be doing something that might be putting another permission in peril.
No, it's just an obligation not to mean what you say. I mean, you're going to be taken as meaning what you give permission for. And if you say it's as a variation, then one understands that to mean what it says.
But, my lord, where does that get us? That is my point. Where does that get us ultimately? Where it gets us to is essentially that planning permission was given, yes, as we've accepted in the Statement of Facts and Grounds, for departures from the master plan. What there isn't in that planning permission is planning permission granted for the stitching in, if you like, of that permission with the wider whole. I simply don't accept that in the absence of a Section 73 permission, because there's an important statutory context here also. I don't say it's determinative, but the context here is, of course, that, as my learned friend accepts, there is no statutory process envisaged by Parliament currently of applying for a variation to or a material variation to a planning permission. We have Section 96A, which refers to non-material variations, but the only other process open to an applicant who wants to use the term neutrally, who wants to vary what they already have, is either to try to do it by Section 73, which, if they're well advised, they will probably be able to do because the description of the development will be sufficiently broad in the root permission, or they've got to apply for a fresh permission. And I'm afraid that is simply the necessary consequence of Parliament not having provided in the Act for a process of obtaining authorisation for modifications or variations of a root permission. And that must be right, I say, in circumstances where my learned friend accepts that none of those additional permissions amounted to a re-grant of the whole with a fully stitched up layout.
So you say it's not possible for the local authority to say, yes, we will grant you this planning permission for this part, But you do realise that that means that when you come to build out the part on the east, you're going to have to make a change to the 1967 configuration of the roads and access.
My lady,
that's really what they needed to have done.
That's what they need, and it's certainly possible. You know, if a local planning authority wants to take that course, then a local planning authority can certainly say, you know, you do realise, don't you, that this will have serious implications for what you want to do for the rest of the site. But the local planning authority never has been, and isn't, I say, under a duty to do so. And I want, if I may, just to push... of course.
When you say, yes, of course they could do that, I mean, is there a formal way? Of course they can correspond with them, but given that this has all got to be on the public register, when you say, yes, the local authority could do that, how would they do that in a formal, publicly available way, signalling to everyone, we realise that when they come to build out the rest of this plan, there will have to be changes to what they do next.
So in terms of a formal process, my lady, the only process that comes to mind under the Act would be if they were to apply for what's called a lawful development certificate, or a certificate of proposed development. What
could the local authority do to signal in a public document that the grant of this permission means that the build out of the rest of it will need some further adjustment?
Well, they could do that. There is a process whereby there's a section on most planning permissions called informatives, and informatives are different to conditions. Informatives have no legal status as such, but there is a section in almost all planning permissions where typical things that will be said in informatives will be such things as, remember that when you come to make the water connection, you'll need to contact the water undertaker for the area. So in other words, not requirements or obligations as such, we find those in the conditions. But if we're looking to convey information to a developer that a particular proposal might have implications for other development, then I certainly can see that it would be possible, if a local planning authority wanted to do so, to use that process, that informal process of informatives. But I do maintain, my lady, critically, they are not required to do so. And could I just go back to the core public law point that my learned friend makes, you know, in the context of judicial review and so forth, saying that we were at fault for how we dealt with this. If we are to say that the local planning authority was under an obligation to assess the acceptability of the relationship between the small development applied for and the wider master plan, we're coming perilously close, in my submission, to saying that there's an effective duty to build or complete that wider master plan, because it's to assume its existence and possibly to turn down the application, let's say, on the basis, well, it wouldn't have an acceptable relationship in daylight sunlight terms with House 27 on the 1967 permission. Well, the developer might no longer have any intention of wanting to build House 27. So it would be completely unfair to the developer to turn down or to refuse the application.
But surely what's incumbent on the local authority is to make it clear whether what it's granting is an alternative or is compatible with the existing permission.
I don't accept that respectfully.
In this context, where it's against the background, where everybody knows that it's being put in wanting to vary the scheme and not for an alternative kind of plan. If what's intended is not to allow it to be varied, but to say, well, if you go ahead with this, you know, then you give up the 401 in return for taking this one. Well, that surely...
My Lord, I don't accept that respectfully, and I say that the history of the case illustrates why it wouldn't be reasonable to expect that of a local planning authority. We've seen a very complex planning history in this case, where applications were being made for all sorts of different things. There wasn't one trajectory here where dealing neatly with one bit, we'll go on to the next, then we'll deal with that. We've seen from the planning history that this developer was changing its mind quite frequently about even what it wanted to do within a particular part of the site. So to say in that context, my Lord, that there's somehow an obligation on a local planning authority to assess all of these different potential relationships with unbuilt development, that would be unworkable. But more than that, it would be unfair to the developer, because it would open up the possibility, as I say, in relation to unbuilt house 27, let's say on the 1967 master plan, of the council saying, well, I'm not going to give you permission for the smaller cluster that you've applied for, because it wouldn't have an acceptable relationship with 27. Well, as I say, the developer might not want to build 27. And the history of this case was entirely consistent with the developer wanting to do something significantly different. Because what we saw and have seen in this case is the development of this site progressing very slowly, but by way of piecemeal increments that over time are advancing a significantly different vision for the development of this site. Now, the developer was entirely within its rights to do that. Entirely within its rights to do that. But in circumstances where it elected to apply for and obtain a detailed permission at the outset, it has to accept that there was a price, a consequential price to pay for taking that flexible approach post-1967. And if there's one point that I can underline in this first hour of my submissions more than any other, it is this. It would really be quite revolutionary as a matter of planning practice to expect a local planning authority to assess the relationship of a proposal with unbuilt development. Because, as I say, what that opens up is the possibility of a refusal for something that the developer might not even want to do. And in a world where we're not seeking to impose a duty on developers to build out a planning permission as a whole, that would be wrong in principle in my submission.
Well, only wrong if the developer hadn't asked for it. I mean, I'm assuming that the cross-references in all but one of the post-1987 single-plot permissions didn't just get there by accident. They got there because the developer wanted them to be there. Now, we've been told that none of the original application documentation was in the bundle before the trial judge, and some concern has been expressed about dragging it in at this late stage, with which I fully sympathise. But is that not a legitimate assumption that if you see it there, it's been asked for?
Well, my lord, facts again are, I say, important. The factual position is, in relation to the post-1987 developments, only a minority, three of the eight post-1987 permissions uses the word variation.
Well,
another four...
Then there's the plot form, the plot
Indeed.
number form, and finally there's an accompanying letter.
Well, let me deal with the accompanying letter. Straight on, which is the letter of the 10th of October of 2008. That letter is at page 298 of the bundle. And I don't accept that this letter supports the construction that my learned friend seeks to put on it. What does this letter actually say on page 298? So the opening paragraph from Mr. Sturkey at the authority, first paragraph dealing with pleasantries. Second paragraph, the situation...
Well, when you say pleasantries, he describes what he's doing as forming a view as to whether the houses shown in the application can be approved as minor amendments.
Indeed. So the letter starts by, as my lord says...
Amendments to what?
My lord, I accept that. The opening paragraph starts with Mr. Sturkey explaining what he's done. He's looked at the history of the site in order to form a view as to whether the two pairs of attached houses on plots 2 and 3 can be approved as minor amendments. But the second paragraph, I say, is critical. The situation is that planning approval 300E for 5 detached dwellings and 5 garages supersedes the 1967 permission. As permission 300E has been commenced, this is now the extant permission on this part of Hillside Park. Therefore, I cannot treat the submission for the 2 pairs of attached houses as an amendment to the 1967 permission. So he's saying that he won't be content to treat that as an amendment of the 1967 permission, because there's an intervening smaller permission, such as the complexity of the history here.
Yeah.
So he's actually saying he's not content to deal with it, because he's saying, well, there's another kid in town now in relation to that part of the site. But then the next paragraph also, I say, is significant. Yes, he goes on to essentially quote the declaration of Mr. Justice Drake in his 1987 judgment, when he talks about a full planning permission could be implemented in entirety. This means that it is only that exact permission as approved that can be implemented without the submission of further details. Well, that's entirely correct so far as it goes. That is, in other words, that is the full permission before the authority. Recent case law regarding minor amendments confirm this view. For the avoidance of doubt, once a variation to the 67 permission is approved and commenced, then the 67 permission on that part of the site ceases to be valid. Now, my lords, my lady, that is an entirely correct statement so far as it goes. Now, what is the criticism made of the letter? The criticism made is that, well, the authority should have gone further than that, and they should also have said that once the development is carried out on a part of it, it's not only that the 67 is invalid on part of the site, it's invalid on the site as a whole. Now,
what a reader would think was that it was common ground between the writer and the recipient that the 67 permission nonetheless remains valid for the rest of the site.
But I say, my lord, when one looks at that paragraph, it is correct so far as it goes, but there is no positive statement in that letter to the effect that the remainder of the master plan can be built out in accordance with it. There's no statement or expression of planning judgment in any way along the lines of, we have considered whether this permission can fit in or can be stitched into the wider layout, and we are satisfied that it can be done. Now, the letter might be criticised, for not containing that additional observation, but it wasn't required. And it wasn't required, my lords, my lady, precisely because of the public law point that I made moments ago. It is not required of a local planning authority to assess the acceptability of the relationships between a smaller development within the site and unbuilt development within that site. So there's, in fact, an argument to be made that it would not have been helpful in that context for the letter to go further than providing commentary on the validity of the 1967 permission in relation to the land actually applied for, because that was the only land that was the subject of the application. And I go back again to my point. My learned friend accepts, no dispute about this, none of the additional permissions amounted to a re-grant of the 1967 permission as a whole. And ultimately, I'd also...
Sorry, can I just ask a factual question on this? Were the proposed houses on plots 2 and 3 in relation to the same part of the site as was covered by planning approval 300E?
They were indeed.
They were.
They were indeed. They were a variation within that zone. But, my lords, can I just take a moment, because we've not heard an awful lot about the difficulties that would arise today if the court were to grant the remedy that my learned friend is seeking. And I would like, if I may, to spend some time looking at the overlay plan on page 438 of the electronic bundle, alongside the points made by the authority's Director of Planning, Mr. Jonathan Corley, in his first witness statement starting at page 399 of the electronic bundle. And if I may, I'd like to take the court through the points made in Mr. Corley's paragraph 12 on page 401, because this, in my submission, will illustrate the practical difficulties that would arise if the appellant's, as I put it, pick and mix approach to different planning permissions were endorsed by this court. So the first point made by Mr. Corley at his paragraph 12A is that 2 rows of terraced houses have been constructed based on the planning permission with the suffix 300B. And just to be clear, my lords, my lady, if we look at the master plan on page 438, that is a reference to the housing that is shown on Zone B on the plan. Now, this might be a point where the electronic bundle is particularly helpful, because if we can zoom in, then the relationship between the grey and the red outline becomes even clearer. But what we can see there in that Zone B is that the westernmost terrace, or terraces, are in a different alignment to the original alignment in red. That's the terrace on the left in Zone B. Well, so be it, that's different. But if we look at the easternmost terrace of the two, a terrace of 2 houses to the right there in Zone B, that terrace doesn't correspond to anything within the 1967 master plan, and it completely straddles a cul-de-sac that on the 1967 master plan was providing the only access to 3 houses shown on the 1967 master plan either side of the letter C on that plan. And as Mr. Corley tells us in his evidence, there's a similar problem that arises because of the siting of the next terrace of housing just outside Zone B to the east. Can the court see that's marked on the annotated master plan, 3 attached pairs possibly built under the 1967 planning application. The annotation is there in text just below the letter C. Yep. Now, we can see again on the master plan, those 3 pairs have cut off another cul-de-sac access to houses either side of the letter D on that plan. And even more problematically, those 3 pairs of houses straddle the siting of 2 terraces shown on the 1967 master plan. Now, to complicate matters further, we've also got some unauthorised garages, now probably lawful by way of immunity, probably, but we've got some unauthorised garages that have been built on the site just to the east again of that built terrace. That's marked. Now, that would make it impossible to build some of the original terrace of 8 houses shown in red directly beneath those garages. Now, if the appellant, my lords, my lady, is correct that in these circumstances a developer should have the legal right to pick and choose the elements of a planning permission that are, as my learned friend puts it, unaffected by the subsequent development, that would open up in this case the possibility of the developer claiming a right to develop each of the houses in that red terrace except the westernmost house which overlaps with the terrace as built, because it's still technically, physically possible to build those 7 houses in red. Now, the developer would claim that right on the remedy that my learned friend seeks from the court, even though, as Mr. Corley explains in his evidence, the relationship between those 7 new houses and the houses and garages already built, it would be completely unacceptable in planning terms because they'd be far too close to each other. So we see here, I say, respectfully, a very good example of what could be a completely unacceptable position in planning terms, because a developer is claiming a right to pick and mix elements from different planning permissions when the local planning authority has never approved and never been, I underline, required to approve the mix of elements being carried out. And then the remainder of Mr. Corley's paragraph 12 on page 402 of the bundle. It's paragraph 12, B, C, D, and then the lettering's gone awry. There's another C and D. But those paragraphs, and it's a point that my Lady Rose has already alighted upon, those paragraphs are dealing with the very problematic state of affairs now in zones E and G of the master plan on page 438. And again, I just want to take a couple of minutes, if I may, just to ensure that we understand what's happened in this part of the site.
Can I make sure I understand what's happened in what you've been taking us to?
Oh, yes,
already?
zones E and G.
No, let's go back for a moment.
Oh, yes.
The three attached pairs, that's possibly built under 1967 planning application, but if what you're telling us is right, they can't have been built under that application, can they?
So,
because they get the problem anything else that straddle the court.
my Lord's pointing, it's a very fine print, my Lord's pointing to that grey terrace there above the letter D, is that correct? Yes. So everything in grey, my Lord, on this plan has been built pursuant to the subsequent additional permissions.
Oh, I see.
And ignore that little arrow note. That's
the description suggests it was possibly built under the original application. But that's wrong.
I see. Yes. Well, if that's that, I see my Lord's point. That annotation is incorrect and at odds with the position as set out elsewhere in the evidence. Because it couldn't be.
But it have been built with some.
I think what the annotation intended to say, my Lord, is that they were three attached pairs, purportedly, possibly, or perhaps.
That's really what I'm getting at. Is this authorised development at all that you're taking us to?
Well, these developments would be authorised now. Well, yes, they would be, my Lord, because in relation to that particular.
The garages we were told are unauthorised, and
indeed.
You have to tell us whether there's any authority for the building of the three pairs of terraces.
Indeed. Well, my Lord, if there's not a formal planning permission for them, which is what is indicated by that annotation, then now, by the passage of time, these would now be immune on the 4-year rule.
Yes, well, that may well be true, but that's not establishing the point you're trying to make, which is that the modifications, that building out the modifications is rendering impossible other developments that were authorised in 1967. I mean, it appears that these are unauthorised development, when you may simply have become time-barred from challenging.
Indeed. Well, my Lord, in my submission, there's no reason why development that was initially unauthorised but has since acquired immunity from planning control, there's no reason why that sort of development couldn't come into play from a physical impossibility perspective either. But I take my Lord's point that in any event, my Lord, the better point for me in terms of the extent of change really is in relation to zones E and G, because, and I alight on those because the trial judge also, as the court will have seen, concluded that what has happened in this area is really problematic from the perspective of going back to the 1967 permission. So just to make sure that we understand what's happened, Mr. Corley tells us in his paragraph 12b of his witness statement, and we can see it here in blue, that an access road was built to enable access to the development in Zone E, right at that northwest corner. And the best way to describe that access road is if we look at Zone G, it's the blue road that curls along the top of Zone G to provide access to Zone E. I can see that the court has seen that. Now we can see there, the point made by my Lady Rose, the lower portion of that blue estate road, as it starts to travel up the boundary to Zone G, goes over the location of a house shown in red on the 1967 master plan. Yeah. But it gets worse. It continues northwards. It goes over the front garden of the house next door before crossing, almost at a right angle, where the internal estate road was shown on the 1967 master plan, before continuing northwestwards and then going straight through the siting of at least 6 houses in a long terrace of 10 houses shown on the 1967 master plan. Now again, if it were left to a developer, and this is the remedy asked for, if it were left to a developer to pick and choose the parts of the 1967 permission that have been unaffected by subsequent development, the developer could say, from the perspective of what's physically possible, well, the 4 easternmost houses in that long terrace, they don't actually overlap with the estate road, so I'm going to build those. Again, as Mr. Corley explains in his evidence, that would be totally unacceptable from a highway safety.
Totally unsaleable in commercial terms as well. I mean, this is fantasy land.
Well, my lord, it goes to, I make these submissions in the context of the remedy that's sought.
But I think when I asked Mr. Banner about the three little pairs of houses where the letter G is, I think he accepted that when you look at the plan which was put in for the build in the additional permission, that area was shown as back gardens, and that in a narrow Pilkington sense would, I thought he accepted, mean that you can't now build those. And I would expect him to say similarly, once you've got permission for and built that road, of course, for Pilkington reasons, you can't build those 4 little houses, even if it could be said that the actual land, the grassy area, is not built over. But it's a question of how much of the rest of the plan is affected by what has happened in that corner.
Your planning officer made this point in the letter you just took us to, that a site like Site G, for which a modified permission has been granted, the modified permission supersedes in respect of that part of the larger site, the original permission.
But, my lord, who is going to make that judgment, and who should make that judgment as to what is now physically possible, to do? I go back. My learned friend is saying, although there seems to be something of a departure from that in his submissions this morning, that the remedy he's seeking from this court is not contingent on making any further application. He is saying simply, can I have a declaration, please, from this court that I have the right to develop housing in all of the areas unaffected by the permissions? Now, who is to make that judgment? Who is to make that judgment? I say that in circumstances where no local planning authority has ever approved the preferred mix of different elements from these various permissions, the body that is best placed to make that judgment in the public interest is the local planning authority. And there's no unfairness here to the developer, that this is the consequence of the developer's election of applying for a detailed consent from the outset and not making use of the outline process that would have given him more flexibility. And there is, as I say, my lord, there is an implication beyond this particular issue of, the houses and the placement of the houses in Zone G. Because, as Mr. Corley also tells us in his paragraph 11D, what we have in that Blue Estate Road is a road built to access a small number of dwellings in the northwest corner of that site in zones E and G. That road has not been approved by highway officers as a road to take traffic onto the tens of homes shown as being in the northern part of the site on the 1967 master plan. Now, that's not to say that it might be impossible, it's going to be impossible to work out what needs to be done by way of further modification to make that relationship an acceptable one. But the mere fact of needing to make that additional application is, in my submission, confirmation that the 1967 permission on its own terms is no longer a permission that can be relied upon.
Well, the answer at the moment seems to me to be that when the application was made, for example, in respect of Site G, if the planning authority had concerns about the implications of allowing permission for that development now shown in respect of the rest of the site, implications for the rest of the site, they could have refused permission or attached appropriate conditions.
Well, to which I answer, my lord, I'm sure my lord will know the answer that is coming. That would be to require the local planning authority to assume that the remainder of this 1967 master plan would be built out exactly as shown there, and therefore potentially enable the local planning authority to refuse the application on the basis of an unacceptable relationship with something that hasn't yet been built.
Well, I don't know which of applications for E and G had which kind of cross-reference to the original master plan. The one possibility is it refers to it by its reference number. The other possibility, it refers to it by reference to the plot on the original master plan. Those seem to be the two alternatives, leaving aside the side letter, which we've looked at in detail already.
Well, indeed, my Lord, and here I'm grateful to my Lord for raising that question, because it's here that we, in relation to Zone G, we are indeed talking about the planning permission that made no reference to variation or to a plot.
So G is the one where there was a side
Three
letter.
pairs of housing.
Can I assist? E, which G sort of comes in the slips from E, was a variation. That's MS 293 PB 13. G was the one that was prefaced by the letter, and it was phrased in light of that.
Yeah.
Thank you.
So G only goes as far, my Lord, as to have that letter by way of preface.
But then answering your rhetorical question in relation to E, the reason why they had to consider that was because it was being asked for as a variation. And the reason why they were, on the face of it, obliged to consider it is because it was relevant to the subject matter of the side letter.
Precisely, my Lord, which is why the estate road was approved on the basis that it needed to provide access to all of those houses in the northwest corner. It was not approved on the basis of it being an adequate access to provide a through route onto all of that. And when we're dealing with a circa 100 houses in the north of the site, and my Lord can see perhaps from the plan how uneasy currently that relationship is. If my learned friend is saying, well, it's simply a case of connecting the road as built with the part of the road unbuilt in red to the north of that, well, first I make the obvious point, no one's assessed the acceptability of that, but simply by looking at that on a plan, one can see in my submission that it certainly appears to be a problematic arrangement in terms of the angularity of the road and the relationship. I put it no higher than that. But one can certainly, in fairness, I think, put it as highly as to say that that is a relationship that requires further assessment and investigation. Because as my Lord put it, it was a road assessed on the basis of needing to provide access to those two sets of houses in Zone E, but not anything other than that, hence its narrowness.
We're going into a level of detail that this court on the facts which we wouldn't normally do. But if you're taking us down this road, we don't have the planning conditions. I presume there must be a standard condition to the effect that all roads have to be built to the standards required by the Highways Authority, and indeed presumably adopted by them before the I'd expect it to be a condition that they have to be adopted before the houses could be occupied.
My Lord, yes, in relation to the development applied for. And here's where we come back to the core issue.
You say, well, the road may be perfectly fine for 8 houses, but it's not fine for 208 houses.
Precisely.
Yes, but in that case, how are you envisaging? It doesn't currently provide. Well, I don't know what you're envisaging. It's shown on this map we have in front of us as having a spur off it into the red road, where it takes a dog leg. But if there were to be some junction like that, it would have to be one which met the approval of the Highways Authority.
Well, precisely so, my Lord, and that's why.
If it didn't, there couldn't be a road.
And that's why I say, my Lord, I mean, no one is saying to this developer, you are necessarily at the end of the road in relation to anything else you want to do on this site. All that the authority is saying is that as a consequence of the decisions you've made about significantly different development as carried out on the site, there are implications now in terms of the onward piecemeal carrying out of development on this site. One of those being that if you do want to build houses in the north of the site, then we're going to need a planning application to regularise something that has not even been assessed or approved by, in highway safety terms, by the Highway Authority, which is a connection, even if a connection is achievable. We don't even know that, given the narrowness of that road. Certainly it's Mr. Corley's evidence that that road is simply too narrow to feed some 100 odd houses in the north of the site.
And you're not prepared to rely on what Mr. Banner says, which is, well, of course we wouldn't try and service 200 houses on the basis of that little road because the houses wouldn't be feasible or commercial. You want the local authority to have
you do, my lady, indeed. And of course I take those sorts of statements of aspiration and intention in good faith. But we are here talking about a regulatory regime.
It's a different regulatory regime for roads from the planning regime.
Well, my Lord, no, the internal, I accept my Lord's point, but the internal road, my Lord, would need planning approval.
Yes, of course it would.
Indeed.
But ultimately, issues of road safety and the like are a matter for the Highway Authority, and it would have to approve whatever roads were built.
Indeed. Which would, in my submission, which would be a material planning consideration for any further planning applications. But highway safety is a material planning consideration that would need to be dealt with in order to ensure that that relationship is an acceptable one. My lords, my lady, I'm conscious of the time, and I've sought to assist as best I can with questions when put. I'm going to move on to the law.
Sorry.
Of course.
Can I just check the significance of your purport of your last answer?
Indeed.
So, as far as what they would be allowed to do without further recourse to you, if this declaration that they sought were granted, that's all those little houses and that road. But I think that you just accepted in response to my Lord Reid that actually, even if we granted that declaration, they might still be required by the Highways Authority, even if not the Planning Department, to amend what is shown and approved on the 1967 plan now to make sure that there is safe access to those 200 houses or so.
Indeed, my lady, and the point I sought to make clear is that would all be done as part of the planning regime, pursuant to that. There isn't a separate consent that one would obtain. It would be part and parcel of the assessment of what, let's imagine the position that the developer comes and says, I want to build the 20, 30 houses or so in the extreme north of the site. Obviously, then, as a matter of planning approval, there would need to be an access provided to those houses. So the question would immediately arise, well, how do we obtain that access against...
Sorry to interrupt.
Of course.
The point is that they want not to have to come to the local planning authority. They just want to do it.
Indeed.
So, but is there anything that you could do to stop them, or that the Highways Authority could do to stop them building out, even though they have, we might hold planning permission to do all that, including the road, to say, well, although you've got planning permission from 1967, now because of what's happened, the roads would not be safe, and therefore we require you to apply for another drop-in planning permission to change what the roads look like?
Melanie, let me answer that in parts, if I may, and beginning at the end. If the local highway authority were to say, well, look, we need an additional consent for this, that would in itself demonstrate in my submission that the 1967 permission doesn't provide a sufficient basis in law for the works that the developer would seek to do in that part of the site. If my lady is asking me, well, if they were to go ahead and just build the houses on the basis of the declaration, and I have not understood the appellant to be asking for a remedy that's limited only to the houses. The remedy is sought in relation to development generally, and that would also include the estate roads. And that must be correct, because I'm sure the appellant isn't coming to the court and saying, could I have a declaration only in relation to houses that couldn't then be accessed? So the declaration critically is also sought in relation to the internal estate road, which in my submission just can't be made to work. And if my lady's asking me, are there procedures outside or in addition to the 1990 Act that would enable or effectively require the closure of the road as built or something along those lines. I've no doubt that there might be such powers in the Highways Act of 1980. I'd need to look at that. I don't know the answer to that immediately. But in my submission, we don't even need to get on to that exercise, because highway safety is a material planning consideration. And the notion, in my respectful submission, the notion that the court would grant a remedy simply allowing the developer to build out the estate road as shown without needing to make any further application to the local planning authority to ensure that that is safe, in my submission, is problematic.
Can I just raise 2 points with you?
Of course.
One is that obviously the planning authority does have legitimate concern with road safety. For that reason, there's usually a pretty standard, well, at least 25 years ago, there was a pretty standard condition that in planning permissions for things like housing developments, that the roads had to be completed to the satisfaction of the highway authority. And often that was attached to a negative condition that the houses couldn't be occupied unless and until there had been approval. Now, if that's right, a condition like that would protect the interest of the planning authority, because there's no point, in other words, building these houses unless and until you're able to provide roads which meet the requirements of the highway authority.
Indeed.
And secondly, apart from that, the highway authority itself exercises statutory powers which would require you to obtain, at least used to obtain a consent from the highway authority before you built the road, and it had to conform to their requirements for things like sight lines and other aspects ensuring safety.
Indeed, my lord, yes. And our concern, my lord, is we simply don't have that protection here. If the court were to grant the remedy that's sought by the appellant isn't contemplating some sort of condition-based procedure whereby this could, because of course the court is not in a position to impose ex post facto a condition on the...
Not. Are you telling us there is no such planning condition in the 1967 consent?
There's no such planning condition, my lord, no, because the only condition in the 1967 consent in this case is in relation to a drainage issue. Yeah. And that was, my lord, a pretty standard, in my experience of historical planning permissions. One of the main changes in planning permissions over time is that they've become more detailed in terms of their conditions. Historical planning permissions tended to be very short in terms of conditions. We only had the one here, which was, as I say, in relation to drainage matters.
And so insofar as there were issues of road safety, those would be a matter exclusively for the highway authority.
They would be a matter for the local. They would be a matter for the local planning authority. In planning terms, it would be the local planning authority to consult.
I mean, if there is no planning condition.
If no planning condition.
You've got no locus to intervene, by the sound of things.
Indeed.
So long as they can build out according to the plan, anyway.
Yes. Yeah.
If they can't, obviously, they have to come back to you.
Indeed.
For a further variation, in inverted commas.
Yes.
But assuming they could build out, then the highway authority could intervene if it had road safety concerns.
Well, my lord, as I say, I don't have before me detailed provisions of the Highways Act of 1980. More than happy to provide a note on that if it would assist. But I would say again, my lord, I would urge the court respectfully to be cautious about approaching the matter in that way, in terms of saying, well, you can go ahead and build it because there'll be another regime to deal with it. It can't be right, I say, as a matter of proper planning, that in circumstances where we say on a proper application of the Pilkington principle, it's become physically impossible to complete development authorised by a route permission because the extent of departures has been such that the developer has lost the ability to rely on it. In my respectful submission, the court oughtn't to consider itself under a burden to try to regularise the position for the developer. Because here, as I say, it's the developer elected the detailed consent process and has elected to take this course of pursuing the implementation of the site in a different way. In the time remaining, my lords, my lady, I just want to deal with the issue, make some observations on the law relating to multiple planning permissions, because there are some authorities which the court might find helpful, conscious, of course, that the court isn't bound to follow the authorities of the lower courts. But these sorts of problems aren't new, and the authorities give us much more by way of assistance in my submission than perhaps is apparent from the submissions of my learned friend. My learned friend's dealt with Pilkington. He's also touched on Pioneer. In the time available, I want to draw the court's attention, if I may, to another Welsh case, because given that we're dealing with a site in Wales, it would be remiss of me not to draw the court's attention to the 1995 judgment of the High Court in the Arfon Borough Council case, and that's at page 755 of the bundle. Now, I apologise to the court for the informality of the transcript in the bundle. This is the only transcript of the judgment that we've been able to source from LexisNexis. The case isn't reported anywhere else except the Journal of Planning Law, but only a summary there, so I'm grateful for the court's indulgence in allowing me to use this transcript. In summary, this was a case, my lords, my lady, in which planning permission had been given in 1958, so another historical planning permission, for the development of a site for private housing purposes. And then another planning permission had been given 10 years later for some 96 homes on the same land, alongside another more detailed permission for some 21 of those 96 houses to be built as a first phase. Now, the issue before the court, could any of those permissions still be implemented? One of the issues considered by the court was this Pilkington issue of physical impossibility, because since those planning permissions were granted, a dual carriageway, so part of the A55 in fact, had been built over a part of the site where there would have been housing on the original plans, and that dual carriageway wasn't even in contemplation when the planning permissions were granted, so the plans made no reference to it. Now, due principally to that dual carriageway, the local planning authority, Arfon Borough Council, it submitted to the court, and it's recorded at the start of the second paragraph on page 767 of the bundle. Due to the dual carriageway, the council submitted, second paragraph, on the basis of that account, the local authority says that the physical situation of the site has changed so much since the planning permission was granted that it is impossible to implement that permission. So in light of that, the judge, Mr. Justice Buxton, considered the Pilkington line of authority and then concluded that the case before him also was indeed a Pilkington-type case of physical impossibility. Now, the main part of his reasoning starts on page 769 of the bundle, the last paragraph beginning in the present case. And one might see perhaps some similarities with the sorts of submissions that we've heard from the appellant in this case. In the present case, one can still build some part of the original scheme that was set out in Permission 84A. That's shown by another plan, and it goes on to refer to other parts of the scheme, some elements of the overall scheme removed from other parts of the original site. And so the developer's submission to the court was, as is recorded over the page, page 770, the last sentence of that first incomplete paragraph on the page. Developer submitted, since some part of the scheme can be built, it is possible to develop under planning permission without reference and its associated schemes, and thus this case does not fall under the Pilkington rubric. And as we see, the court rejected that submission for three reasons, only the first two of which are relevant to the facts of our case. First, the judge said, it seems to me wholly artificial to think if one builds only a comparatively small part, not a token part, one is really in any sense doing that in implementation of the planning permission. Indeed, Council went so far at one point to say it would be consistent with his argument that even if one house was built, the impossibility argument would not arise. But I rely on the next bit. Planning permissions 84A and 6110 assumed an expensive layout using the whole of the site for particular purposes, including recreational purposes and, for instance, with an estate road running through the site with 2 exits, whereas on what is now proposed there is and can only be 1 exit because the area where the other exit was to be is covered by other and unrelated housing. Then I move on to the second and perhaps more fundamental conclusion for my purposes on 770. Next paragraph. Secondly, the suggestion that other parts of the 84A arrangement could be moved to a new location is, in my view, not helpful. It was agreed that that would need a variation of the original planning permission. The local authority might or might not be minded to agree to such a variation. Quite apart from the issues in this case, there might well be, we don't know, planning considerations that enable them or possibly even compel them to refuse such variation. But I focus on this sentence. I cannot think that it is an act of implementation of the original permission to do something that needs a variation of that permission before it can be legally done at all. I naturally rely on that last sentence in support of my case. I estimate I have just under 10 minutes remaining. I think I started at 2:25. The court will tell me if I need to finish earlier than that. In the time remaining, I'm just going to deal, because I do deal, or at least I've sought to deal with everything fully in my written case. But there are some matters in particular that I wish to highlight. In particular, we've dealt, I think, adequately with the first of my learned friend's submission. On the point, his second submission, that the modification he proposes of the Pilkington principle would be consistent with its status as what he calls a subspecies of the principle of abandonment. And the point he makes here is, in simple terms, if you asked a reasonable person to consider the facts of Pilkington, the reasonable person would assume that the earlier permission in that case to build the house had been abandoned when the other house was built under the later permission. My learned friend says, well, if you presented the facts of the present case to the reasonable person would conclude, looking at the facts on the ground and all of the relevant permissions, that the developer was still intending to rely on the 1967 permission. I invite the court to reject that submission. If we are asked, for the sake of argument, to contemplate what a reasonable person would think if they stood on this site with all the relevant permissions in their hands, they would surely see, would they not, that a road has been built over land where several houses were planned to be built under the 67 master plan. They'd also see that houses have been built on land shown in the master plan as land to be used for a road. So presented with that state of affairs, it's inconceivable in my submission that a reasonable person would think that the developer was still giving effect or intending to give effect to the 1967 master plan. What they would conclude instead, in my submission, is that the developer has elected to develop the site in a significantly different way, bringing forward piecemeal increments of development, adding to development that's already departed from the 1967 master plan. So this notion that the reasonable person would think that the 1967 master plan was still to be carried out, when I stress again, precisely none of the development on the site accords with the terms of that 67 permission, that I say, with respect, is unrealistic. I'll then deal with my learned friend's fifth point, that the appellant's modification of Pilkington would provide certainty and predictability to all parties, because everyone will know when additional permissions of the nature obtained in the present case are in play, and everyone will know, he submits, that the effect of them is to preserve for the developer the right to carry out the original permission in the parts of the site unaffected by the additional permissions. The problem with that submission is that it proceeds again on what I say is the false assumption that a local planning authority is required to relate planning applications for different developments on the same site to each other. And there is simply no obligation, and the facts, as I say, of this case are important. Only a minority of the 8 permissions granted on the site since 1987, 3 of them, as we've seen, use the word variation at all. So the notion that the practice followed in this case would enable the public to know with certainty and predictability that the additional permissions are all still preserved by the developer's right to rely in part on the 67 permission, that is not, I say, borne out by the facts when only a minority of the post-87 permissions use the term variation. In any case, if the concern is to provide certainty and predictability, the statutory planning code already provides for that. Because as Mr. Justice Hickinbottom told us in his judgment in Singh, as he advised us at paragraphs 33 to 34 of that judgment, and it's page 818 of the bundle, if a developer wants in effect to change a planning permission, he or she can do one of 3 things. He can consider an application to Section 96A for a non-material change, if that's open to him. Secondly, he or she can consider making an application under Section 73, and that can allow for different plans to be approved. Or thirdly, if he can't bring himself within either of those procedures, then he'll have to make a fresh application for planning permission. And if we put certainty and predictability to one side for a moment and consider a competing objective of flexibility, I maintain that it is highly relevant, my lords, my lady, that it is only now, in the very recently published Levelling Up and Regeneration Bill, that a proposal has been made to insert a new Section 73B into the Act to establish a new procedure for seeking planning permission for development that won't be, and I quote, substantially different from an existing permission. And the fact that it's only now being proposed that there should be a power added to the Act for planning permission to be re-granted, or for the ability to re-grant planning permission, subject to minor material amendments. That is, I say, a tacit indication, at the very least, that such a process is not currently, and hasn't been, within the statutory framework of the Act. The last submission that I'll deal with in the 2 minutes remaining is my learned friend's 6th submission, where, and I've touched on this already, but where he has sought to characterise this case as one that has substantial implications for the planning industry. The first point to make in response is that many of the articles that he cites by way of evidence, they take a pretty measured approach to the judgment of the Court of Appeal, and they correctly don't regard it as a game changer on the law relating to multiple planning permissions, but instead they regard it as an entirely orthodox application of the Pilkington principle to a set of particular facts, which is entirely, I say, what it is. If we look at the first article, we've already looked at one of them, but if we just look at the first article on page 538, this is an article from the Planning magazine. The author of the article sets out the facts, refers in the second paragraph on page 539 to concern expressed by some that the court's emphasis on a holistic approach could have implications for the use of drop-in permissions for multi-phase developments. But then the article ends with much more measured commentary. If we look at the last 2 paragraphs on that page, I won't read it all out, but again, our friend Mr. Rickett saying, each case turns on its specific facts, We shouldn't just accept that it has wider implications. And then Mr. Corley, again reappearing in this article, giving a quotation on the part of the authority, and in my judgment, again, offering perfectly measured commentary on the judgment, saying that it was simply a reflection of the fact that the original scheme was totally incompatible with the subsequent permissions at the fact and degree point. Small amendments, Section 73 changes, drop-ins should all still be perfectly possible, but there's a point where it is physically impossible to build the original scheme where it goes too far. And that is the big lesson. And indeed, then, just briefly over the page, so just so that we don't rely on Mr. Ricketts alone, Mr. Charlie Reed, Senior Associate at Ashurst, he said, last sentence, the case doesn't change the status quo, but where subsequent planning applications are made, care must be taken to ensure they're consistent with the route planning permission if there's to be continued reliance on that consent going forward. So, in my submission, the evidence of those articles, so far as they go, I mean, the court will make of those what it will, but I need to deal with it, as I say, because of the way that the case has been presented to the court. In my respectful submission, the effect of the judgment of the Court of Appeal has been overstated by the appellant and my learned friend. The phrase drop-in permission wasn't even mentioned in the courts below, and the courts didn't suggest either that the case had any implications for the use of those and the Section 73 regularising permission. This was a judgment made on a particular, might be said, unusual set of facts dealing with a very old planning permission where the developer had elected in 1966, before the 67 permission was granted, to take the route of a detailed consent where perhaps on reflection and in retrospect, given what it perhaps intended to do or certainly ended up doing, it would have been prudent to have applied for an outline planning permission instead.
Mr. Lewis, that sounds like a peroration.
It does indeed, and I do end there. My lords, my lady, unless I can assist further, those are my submissions.
Thank you very much.
My lords, my lady, I'm conscious of the time. I'll do my best to do my reply as quickly as possible. Firstly, Mr. Lewis characterised my case as asking the court to modify the principle. At least as my primary submissions, I'm not. I'm asking it to elaborate upon the qualification within it. If you think that that's not right, then obviously I do, as a secondary point. Secondly, to be very clear, I did not and do not concede that a new planning permission is necessary. What I said is that one might happen as a matter of fact, and that is true, and that would be one potential outcome of this. Thirdly, to be clear about the characterisation of my case about what the additional permissions were, the paragraph 48. My starting point is paragraph 48, as I said, and incorporation by reference is one way of looking at it. Another way is endorsement. It doesn't actually matter for the purposes of my core submission, because what does matter is it's plain that precisely whatever their legal nature was, they intended to authorise the development to carry on, to borrow my Lord Legate's phrase, carry on subject to the amendment. I think you said it slightly more felicitously than that, but there we go. Next point is a large part of my learned friend's submissions, an essential part, cut fundamentally across the findings of Mr. Justice Drake and the findings of His Honour Judge Keyser in relation to the pre-1987 permissions. I've dealt with that already, but note that it's fundamental. Next, my learned friend talks about the difficulties a local authority might have in identifying whether a particular application was a variation application, and therefore triggering the need for the inquiry, the planning inquiry with an E, that I mentioned earlier. Well, no, because if the planning permission objectively construed is a variation permission, then just as it would be possible for anyone after the event to ascertain that it was such, applying general principles, so too would it be possible for the authority to ascertain that it would be. My own friend talks about election. I'm very, very careful about the use of the word election, given what was said in Pioneer about abandonment by election being something that's not known to the law. But of course, there's no election here as a matter of fact, because we were encouraged down this route. Indeed, the permissions themselves, my Lord Legate, said, you may vary, and yet now we're being told that by implementing permissions prescribed as variations, we have destroyed the earlier permission, as my Lord put it. Drop-ins. I mean, my learned friends seem to think, well, there might be a scope for drop-ins, but only in relation to, say, garages. Well, there's no coherent explanation, principled in law, fit for this court to find, as to where one would draw the line. As it happens, a garage or window frames or something like that in a wide development, they'd be non-material amendments, so they'd be caught by Section 96A. So actually, my learned friends' analysis, there is no scope for variations at all, and we know that's wrong. For the reasons given by Mr. Justice Drake and His Honour Judge Keys. I noted that the court may have seen in past the other Welsh case, the Aberfan Walton case, there's reference there to variations actually as one potential future thing that could be done. My learned friend seeks to characterise the consequences of this case as not applying beyond it because drop-ins, as he put it, were some tightly defined concept as set out in the article. Well, a fair reading of the article, I would submit, is not that it seeks to confine drop-ins that way. It's given as one illustration. To be very clear, this is how outline permissions. Can I ask the court to turn up one last time paragraph 40 of my case? And as my learned friends makes great play on Mr. Ricketts is sitting behind me. He contributed to paragraph 40. Page, sorry, MS. Oh, goodness me. I had it in my opening. Can somebody bear with me? The version of the copy I have isn't...
64, perhaps?
Paragraph 40. 64, yes, thank you, my lord. 64. Section 73 doesn't apply where you need to change the definition of development, and Section 96A doesn't apply where the change is substantial. Imagine an outline permission for a large development over multiple successive phases, which contains a office block. And imagine that office block, in light of the pandemic, is no longer viable because of numbers of people working from home now. There's a proposal to change the description of the development to a hotel, for the sake of argument. That would be a change to the descriptor of the development. You couldn't use Section 73 for that, and it may be thought that was material for any sorts of reasons. That would be affected by this. That's just one example I was able to think of in the last half an hour, for example. So outline permissions are caught by this. This is not an issue to do with reserve matters cases alone. There are other examples, including in what follows paragraph 40.
It also indicates that the forms of development that may be caught are not restricted to physical development, which would be changes of use. Yeah.
Yes, I mean, I'm loath to give evidence on the bar, but having advised on this matter a lot in the last year, that is right. Just bear with me one moment. Yes, my learned friend made great play a number of times on saying, well, the local authority, if I'm right, would need, when considering variation applications, to consider the effects on future development, and that was revolutionary. He criticized that, and I've said twice. It's not. Let me give at least two examples. One, you'll find the law, which is development that triggers the need for environmental impact assessment, which a lot of development of the scale that's affected by this problem would do. Environmental impact assessment requires consideration of in-combination effects with other development, cumulative in-combination effects. I think it's Schedule 4 of the latest version of the regulations, but the court will be familiar with it, having heard countless EIA cases over the years. And in combination, it is trite that in-combination effects with other development include other planned development. So interplay with other planned development is something already mandated by the law as a mandatory, I think that's Fewings 1, isn't it, material consideration in relation to such development. So the Irish Revolution is fundamentally wrong. Secondly, even a non-EIA development, for instance this, and I am, as it happens, taking an illustration from personal experience. Two tall buildings in London, both have consent. Both are either not yet occupied or part built or not yet built at all, but the permission's alive, and one of them wants to go higher. And the question then is, well, what would the impact be on the daylight and sunlight and thus residential amenity of the adjacent tower? That's not uncommon in central London. And of course also the impact of a proposed development on the ability to develop another site because of the potential prejudicial effects it might overshadow a car park and mean that car park is no longer able to be viably developed for housing when it's allocated for housing. That sort of issue comes up. In fact, my very first case at the bar was about that very thing. So there's three examples.
So what if you've got the two tower blocks, they've both got permission for 15 stories. One of them is built, but only to 6 stories, and the other one is built to 15 stories and then wants to build an extra 5 stories. Now, there's no problem with light for the 6 stories next door.
They'd have to have regard to the impact on the future occupants of the upper stories.
So they have to refuse that planning permission for the additional 5 stories because it would affect the light of people who are living on the, at the moment, non-existent floor 15 of the neighbouring one.
Absolutely, that's Route 101 planning.
It occurs to me, for example, in the days, I don't know if these things still exist, but in the days of the store wars, you were dealing with the
competitive effects of retail.
Yes, exactly. You would take account of every planned superstore within a radius of about 30 miles and try to work out what the effects would be on how well consumer demand was being met. Planning
is largely about anticipation. That's the name of the game. Next point of reply. I'm going to deal with the points of law, and then I'm going to deal with the very quickly with the mini planning inquiry you heard for most of this. The Levelling Up Bill. Just to be clear, it's not seeking precisely the same thing as I'm asking the court to find, because the Levelling Up Bill would introduce an actual power to amend in a literal sense. So it's not in any sense a recognition of what the law currently recognises in the lacuna, in the gap, if you like, in legislation, not any sense of recognition that doesn't exist. And I've given my submissions anyway on that by reference to the Levelling Up Bill explanatory notes. Then lastly, in terms of the various detail points, I want to preface this. So the points of detail, and dare I say, a lot of speculation as to what may or may not have happened, what may or may not have been said. They weren't the subject of any real debate or evidence before the court. Indeed, you've seen the paucity of actual contemporaneous material before the court, because the local authority's position before the High Court was the extreme one. That I remember going back to Mr. Lewis's opinion, which was no more and no less the rationale for the change of stance. This can't be done by virtue of the pre-87 and the post-87, with no attempt to distinguish between the two. It was an absolutist position. The parameter of the debate has moved as the case has gone up because Mr. Lewis lost a large part of his argument below. And the detail that he's now seeking to speculate about as to make good the residual part of his case wasn't before the courts below. So just that's an important point of caution in relation to a lot of what you've heard. Can I ask the court to go to ideally 2 places as possible in the electronic bundle? 299, which was our plan, if I can call it that, and Mr. Maiden's witness statement, MS 425. Because Mr. Lewis made his various submissions on the practical consequence, if I can call them that, exclusively by reference to the local authority's plans. And Mr. Maiden gave evidence in relation to that before the courts below, paragraph 6 of his witness statement, the second witness statement, doesn't accept the plans produced by Mr. Gore are accurate, at least not near as accurate as I produced, which include 299. And he gives the reasons why, not least because they're based upon a survey information and a little bit further down, computer-assisted design model inquiry, whereas the implication being Mr. Corley's were essentially a Heath Robinson job. So I do ask, and that wasn't challenged. There was no application to cross-examine Mr. Maiden. So I do suggest that if, insofar as anything turns upon the differences between these two plans, not open to Mr. Lewis to rely on this court unilaterally upon the plans which were criticised in evidence, which was then that evidence was not challenged. And if one looks at paragraph 299, it may well be, as my lady Rose pointed out, that there are important differences in the picture portrayed. I mean, very broadly speaking, if it may or may not assist, what I've done here is I've sliced the site up into three parts. Essentially, below here, that's essentially pre-87. That's essentially governed by post-87. That's the rest. And that's that in broad sense, in terms of the letter talking about this part of the site, that's in broad terms the consequence of the argument I put forward. The roads do match up.
But there don't seem to be any way of getting to 6, 7 to 12. How do you get into those houses? Doesn't seem to be any road.
I'm sorry, I can't see on my number 6, 7 to 12. I do apologise. This is where the electronic version does help.
There'll be on 48.
Well, yeah, sorry, I do forget. Yeah, and it may be if there are some aspects of the development which can't be accessed. Don't say they are. I think that's actually about the granularity of the plan. I think if one looks, it would be possible to access them. But if there were one or two houses that are physically impossible to construct, then the Pilgrim Provincial might apply to them. But what it doesn't do, I mean, what this case is really about in substance is all of that. And that's the real battle. That's in reality the real battleground of this case. That huge amount of development over there, and can it be physically accessed yet? Can it be? Yes. Can it be built? Yes. Might it be that the authority now thinks the access isn't quite like what it would like it to be? Well, so what? For the reasons I've already given, it can always revoke and give us compensation. And I've said, see what I've said before. In terms of the position in relation to highways, and again, with the preface, I don't accept any of that discussion relevant at all for the reasons I've given. Could I ask the court to go to page 202 of the bundle, if you can, keeping 299 to hand. 202 is from Mr. Maden's first witness statement, and at the very top of that, you should have the second part of paragraph 22. And you'll see there that you say Hillside Parks is invested in constructing the spine road at the northwest of the path to the site. I'll be correct, my understanding is that's basically the dark blue on 299, which has been adopted. There was no condition requiring adoption, as far as I'm aware. We've looked, but Gwynedd has adopted the effectively dark blue, if that's right, or dark turquoise. Moreover, all the works undertaken have been acknowledged with the knowledge have been carried out with the knowledge and cooperation of relevant statutory authorities. So no evidence the Highways Authority weren't consulted, as they would have been, because highways authorities have to be consulted in relation to development affecting, for example, proposed highway, actual highway, access to the highway, etc. So they would have been consulted. The presumption of regularity, which I think is actually the right presumption rather than formal validity in this context, presumes irrefutably, absent evidence to the contrary, that they were consulted. You presume that the processes that should have been gone through were gone through in administrative acts, absent evidence to the contrary. Omnia, we say yes, well, I did do classics about 20 years ago. But so they're presumed to be to have been consulted. No evidence that they objected. And moreover, as a local highway authority, they have certain permitted development powers in relation to, again, you don't have this before you because this is a new point, but we can provide a note if you need. But they have PD powers. There's the power under Section 278 of the Highways Act to enter into an agreement with the highways, because normally when you build a development that requires modifications to off-site roads, you don't apply for planning permissions to the public highway. You
have a planning permission. Are you saying that there are things that they can do to stop you building out?
No, quite the contrary. No. There are things they can do without planning permission to deal with some of the problems Mr. Lewis identified. Quite the contrary. So, for example, if it's a problem that where the spine road as currently proposed marries up with the rest of the road, if there's a highway safety problem, well, first point is, so what, because it should have been considered at the time. My second point is actually, as a matter of fact and law anyway, in any event, not that this is necessary for my argument, it would be able to be resolved under the Highways Act, because there's provision under Section 278 to enter into an agreement with the Highways Authority to do works to public highway. There's also power to have adopted road that isn't adopted, so the bits that are currently not adopted could be. So there's all sorts of ways which the, frankly, jury points my learned friend makes about highway safety could in fact be dealt with, albeit for the purpose of my lords and my lady, you don't need to go there for the reasons I've given. Let me just check.
Yes.
The
is there anything?
I don't think, unless my lords wish to. I think the letter speaks for itself. I don't think I need to go over what was or wasn't said. So, unless
there is one point I'd find out, not now, but after the hearing, if you could agree between you what the actual position is regarding the houses described as possibly built under the 1967 planning permissions, which are numbers 18 to 23 on 299, so if it's possible to supply that information.
We will do it next week. Yes. Or this week even, it's Monday, isn't it? So it feels like Friday already. Yes. No, we'll do it ASAP. Thank you. My lords and ladies, if you've got any further questions, those are the submissions.
Thank you very much, Mr. Banner. And thank you also, Mr. Lewis. And we're grateful to the assistance of all those who've contributed to the submissions we've received. We appreciate this case has an importance on its own facts to the parties, but it obviously raises an issue of much wider importance. We'll take time to consider our decision and let you have our judgment in due course.